Now we have a January 1, 2027 deadline.
Most of the time, we are very good at writing policies. An auditor comes, I have a policy.
How do we make it stop? When will this problem finally end?
Otherwise, it will just be up in the air with no owner, no one to drive it. The data subject has a right to ask that decision be reviewed by a human. That right is guaranteed under the PDPA.
Just because the law maybe gives us 2 sentences, automated decision making, it doesn't mean that this is a free hall pass for you.
Yeah, because the principles of the law would apply regardless.
Welcome to The Exchange, an educational podcast by DL and F. Desaram. As one of the pioneering podcast initiatives by a law firm in Sri Lanka, The Exchange aims to make the law more accessible by exploring how legal developments shape our everyday lives, businesses, and industries. Through insightful conversations with legal professionals and industry experts, we unpack complex legal issues, discuss emerging trends, and provide practical perspectives to help you better understand and navigate an increasingly complex legal and regulatory landscape. With Sri Lanka's Data Protection Act coming into effect gradually, organizations have entered a critical period of preparation. In this episode, we're breaking down what the latest developments mean, the practical steps that businesses should be taking now, and how to build a privacy program that goes beyond simple compliance. Whether you're just getting started or refining your approach, this conversation will help you understand the Personal Data Protection Act and to be PDPA ready. I'm Thanuki Gunasinghe, Counsel, Technology, Media, Entertainment at DLF Desaram, and your host for The Exchange. Joining me today is Ms. Shenuka Jayalath, Consultant Counsel at DLF Desaram. Shenuka was a member of the committee that drafted Sri Lanka's Personal Data Protection Act and brings extensive experience in helping organizations design, implement, and operationalize privacy and data protection programs. So let's unpack this. Hi, Shenuka.
Hi, Thanuki.
So to set the scene, could you walk us through where Sri Lanka currently stands with the implementation of the PDPA? What has been operationalized so far? What changes have been introduced through the recent Gazette? And what those developments mean for organizations?
Okay, so the Act came into play in 2022. That's when it was passed. And the Act actually, there were certain sections in the Act which mentioned that certain parts of the law would become operational by XYZ dates. And those were the time limits given. So flowing from that, there was a Gazette passed in 2023 where the Data Protection Authority was formed by the operationalization of Part 5 of the law. And the authority has been in play since 2023. And thereafter, there was another Gazette in 2024, which mentioned March 2025 as the day where key provisions of the law would come into operation. But this was later repealed, and the Act was amended, and all those timelines were effectively removed. And once the timelines were removed, it was very simply the Act will come into operation on a date the minister publishes in the Gazette, the date on which it will come into play. So following that, we saw the recent Gazette, which is in 2026 July, the recent Gazette which was passed, which brings into operation Section 2, Section 3, which deal with the applicability of the law, and Part 1 and Part 3. So Part 1 essentially is your obligations under the law, your data protection obligations, the processing principles as they were. And Part 3 deals with controllers and processors and all the obligations that flow with it. What's interesting to note is that the data subject rights, which are also ensured under the law, and the penalty provisions have not been gazetted. So that means that those will come into play at a later date.
Right.
So that's what it is in a nutshell.
Right. Definitely a lot to take in. We've gone through a very tumultuous period of change when it comes to how this law has come about. So now we have a January 1, 2027 deadline. And with that approaching, what should organizations be doing to prepare?
So I think if you haven't started already, if you haven't read the act, the first step, of course, is read it and see what your obligations are under the law, because there are many, and it's not something you can switch on and off like a light bulb, like a light switch, and you'll be compliant. There's a lot of things you need to look at, a lot of things you need to prepare for. So first step is look through and see what your obligations are, identify that, be advised on what your obligations are, and start setting in place your management program, which is again a requirement under the law.
So, in terms of preparation, we'll go into that a little more in detail. What are the key elements of an effective privacy and data protection program, and how should organizations begin to build one?
So we get asked this question a lot. How do I do this? Because Section 12 of the law, it simply states you need to set in place a data protection management program. And there hasn't been any guidance formally published up to date. So this question comes up a lot because a lot of people, it's not something Sri Lankan companies have experience doing. And it's not, this is a new topic for everyone. So if you look at what a data protection management program is, essentially it's the end-to-end program by which you as an organization would manage how you process personal data. And that program, it can't be something that is just written on a piece of paper. Most of the time, we are very good at writing policies and having it there. So if an auditor comes, I have a policy. But a data protection management program needs to also be effective. That is specifically mentioned in the law. And it will also be the effectiveness of this data protection management program will be a factor that the Data Protection Authority will consider in the event they impose a penalty. I know the penalty provisions are not coming into force in January, but they will come into force at some point in time. And at that point, if you do face a situation where you are under investigation or you have been asked to show cause, or the authority is really looking at penalizing you for a breach, the effectiveness of your management program will play a huge role in the authority essentially identifying whether or not they should impose the breach or to what severity the breach has impacted your organization and how much the penalty should be. The monetary value also would be considered based on the effectiveness of your program. So in a nutshell, I mean, a management program is very extensive. I'll break it down very simply. You have to have your governance layer in place as a first step. That would be your policies. So again, it's not just a piece of paper, but the piece of paper has to be there. You need to document, this is how my organization processes personal data. This is the data I collect. This is what we do. And alongside the policy should be a team of individuals who would take this program through the organization, who would operationalize it within the organization. And one of the key personnel under that program and under that team would be the DPO, the Data Protection Officer. Now, under the law, not every organization needs to appoint a DPO. That we need to look into the law. You need to look and see whether your processing activities, your organization would fall within one of those categories where a DPO is mandatorily required. So, for example, public authorities have to have a DPO, and even organizations processing large volumes of high risk sensitive data, they will need to have a DPO. But even if you don't fall within those categories, there's no bar on you having a DPO, and having a DPO would also ensure that you're advised well on your the requirements, your obligations under the law, and that your program has an owner. Because otherwise it will just be up in the air with no owner, no one to drive it. So alongside the DPO, you need to have a team, a cross-functional team within your organization. It's not just a legal problem. It's not just an IT problem. It touches across every business vertical, HR to operations to business units. Everyone needs to be a part of that team. So that's your governance. And then you have to move on to assessing what you have, as in start the process proper. When you say assessing, this is not by no means an easy task. It's one of the hardest parts of your program, because right now the way organizations have been functioning, we've been having a lot of data in-house, and we don't know where the data sits. We don't know what the data is. We don't even know whether we need it. And sometimes we don't even know there is data stored somewhere. So finding those, finding that magnitude of information is part of your assessment piece. It's a gap analysis of sorts. So once you do that and you know what data you're processing, then you need to also identify your legal basis for processing that data. And if you don't need it, how do you dispose of it, right? Then you move on to protecting that data, your protection mechanisms like your data protection impact assessments. Again, very critical for high risk processing activities. If you're not sure whether the activity is high risk or not, you should perhaps do one anyway. So your information security, cyber security, all those practices, your physical security measures are your next step. And then the third step is, of course, your monitoring mechanisms like your audits to make sure the program remains relevant and it still keeps, all the functions are still processing data in a compliant way. And the last one is basically your responding abilities to a breach, to a data protection authority request or a data subject request. You have to have processors in place to respond to all those scenarios.
Right. And that makes it very clear then that if you still as an organization haven't gotten your hands on this process, it's going to be very, very tedious on you if you decide to immediately get into this very close to the January 1 deadline. And I definitely think that this is a very interesting point that we keep making, and it's a repetitive point by this stage. All right, so let's go a bit into detail on sectors. Let's get sector specific, right? So when you look across the Sri Lankan economy, which sectors stand out as having the greatest need for robust data management and protection practices? And what are the key issues that they should be thinking about and working to address? So maybe you can comment on 2 to 3 different key sectors.
So first off, I have to say the law applies to you whether you're a large organization or whether you're an SME. It applies. So there's no sector where you have to say it applies to X, Y, and Z sectors, and the rest can take it easy. That's not the message. But there are certain sectors which process a high volume of data. And by that very nature of that processing, it becomes very high risk because there's so much of data involved. And some sectors process very sensitive personal data, special categories like health data. Yes. So I would say health sector is, again, one of the most critical sectors, specifically because you're touching on people's health data, you're touching on data relating to children. Yes. So all that, it places a heavy burden on you to comply, and it's a large volume. The other is, of course, the financial services, banking sector, because again, large volumes and so many years and years of data. You have physical documents, not everything is online. Right. So it becomes very challenging, and there's a huge onus apart from your other sectoral regulations regarding secrecy and confidentiality. The PDPA places a heavy burden. So I would say banking sector would be heavily, they will need to really get their hands on this piece of legislation and see how they need to implement it. The other is, of course, telco sector. Again, large volume of personal data, location data, all that is processed. BPOs, and of course, public sector. Public sector organizations process a large amount of citizen data. So there's a large burden on them as well to comply.
Yeah, I think I want to pick your brain when it comes to the telecommunications sector, because a frequent question that we get as lawyers is, I keep getting a lot of unsolicited messages. How do we make it stop? When will this problem finally end? So since we know it's not operationalized yet, how do telecommunication organizations approach this better?
I think perhaps not many people are aware there are already sector regulations regulating the dissemination of promotional messages to consumers. And there are very strict rules. There are time periods within which you can't send. There are quotas of messages you can send a day. There are blackout periods. So all these things are already covered in sector regulations. But for PDPA, Part 4 is not operational yet. And Part 4 essentially is an opt-in regime where you need to opt in to receive the promotional messages. Right now, what we have is an opt-out, and that is, as per current regulations, it's lawful. But once the PDPA provisions also come in, it's a bit of a shift in the whole dynamic, and we'll have to wait and see when the Gazette will bring that part into operation.
Yeah, that'll be a definite area to watch. And I think one of the areas that the general public understand a bit better and will feel the impact of the PDPA when it becomes operationalized. Now moving into AI, because everybody is talking about AI, there's no conversation that happens without it. So as organizations increasingly adopt AI, how should they adapt their privacy policies, data protection impact assessments, and broader data protection management program aspects to address the AI-related risks?
So AI is here to stay. That's very obvious. Every organization, every individual uses it today, I would say, for a lot of tasks. And the interesting thing about technology is that always the technology develops at a faster pace than the regulation. So AI laws are no different. I mean, you see them coming in Europe now, but nothing has moved to this part of the world yet. And in Sri Lanka, we don't have AI-specific laws. Yes. But if you look at the PDPA, again, there are certain aspects of the PDPA that we can make use of when we are using AI to protect personal data. One thing is automated decision making is covered under the PDPA. And if a controller is using automated decision making like an AI tool to make decisions about people, the data subject has a right to ask that that decision be reviewed by a human. That right is guaranteed under the PDPA.
Right.
Also, if you are using AI for things like profiling or analytics, the principle of transparency under the law, it mandates that you disclose that fact, that I am using AI tools to process your data. And of course, if you choose to profile and you choose to do analytics, if you can anonymize that data, that would be one of the technical and organizational measures that you could ensure under the law to process that data safely. And the provisions of the law would essentially not apply because there's no personal data that you're processing. It's anonymized. So all the personal identifiers have been wiped out. So that's a safe way you can use AI.
All right. So I think what you're saying is just because the law maybe gives us 2 sentences about automated decision making, it does not touch extensively on what AI is. It doesn't mean that this is a free hall pass for you. You can definitely interpret that expansively and adjust your programs to address it.
Yeah, because the principles of the law would apply regardless. And if you're using AI, it could be high risk also. So a data protection impact assessment should be mandatory in your AI. If you're using AI at this point, because of the bias and all the things that can come along with AI, you have to do an impact assessment before you deploy those tools on personal data.
And would you say that an AI impact assessment should be conducted separate to the DPIA, or can they be combined in one?
Well, there's no harm in combining as long as the data protection aspects are fully covered, because it would, of course, operationally, it would make things much easier if you can combine. As long as you can demonstrate to the authority, I have looked at data protection considerations when I did this impact assessment, that should satisfy a requirement.
Right. All right. So in closing, many organizations may still be wondering where to begin. I know we keep circling back to this, but this is a ground reality of the situation in Sri Lanka. If you could give them one priority as they prepare for the January 1 deadline, what would that be?
I would say clock is ticking. you have less than 6 months left in the year to comply, and you should use the time wisely. Get advised on your obligations, see whether you fall within the definition of a controller or a processor, see what your obligations are, and see whether what you're doing is lawful, and get things rolling.
All right. So, as the compliance deadline draws closer, the time to prepare is now, and we hope you do. And with that, we've come to the end of this episode. Shenuka, thank you once again for joining me and for the insightful discussion. I thought this was very, very important and timely to have this, considering that the Gazette just came out maybe a week or two ago. Thank you for joining us on The Exchange. We'll see you in the next episode as we continue exploring legal issues that impact businesses and everyday lives.